Stop, look, and listen. It's a requirement Congress and the courts have placed on federal government agencies, like the Food and Drug Administration, to conduct before making final regulatory decisions, such as deeming vaping products to be tobacco products. The requirement is called coordination, and it goes beyond soliciting public feedback and consulting local officials. It's a mandate to coordinate regulatory initiatives with state, local, and tribal governments in order to limit the impact federal regulations could have on local communities. After 40 years of U.S. lawmaking, language codifying coordination is scattered throughout the U.S. legal code. It's detailed in federal agency policy and marshaled by presidents through executive order. It was in fact Bill Clinton who went first and farthest in delineating the need for coordination and then ordering federal agencies to coordinate. In a 1993 executive order, President Clinton set forth the objectives and requirements for U.S. regulatory reform. He stated the objective for federal agencies is to enhance planning and coordination with respect to both new and existing regulations. With regard to state, local, and tribal governments, President Clinton specifically ordered all federal agencies to seek the views and involvement of officials before imposing regulations which may be inappropriately burdensome. Federal agencies are also directed to assess the effects of federal regulations and seek to minimize the impact likely to result from a rule that may adversely affect in a material way the economy, a sector of the economy, productivity, jobs, and competition. Finally, President Clinton specifically encouraged state, local, and tribal governments to assist in the identification of regulations that impose significant or unique burdens on their communities or are otherwise inconsistent with the public interest. While President Clinton issued his executive order in 1993, it still remains active today, as Presidents Bush, Obama, and Trump all chose to build on the order. So what does this all mean? Well, it means that before the Food and Drug Administration promulgated the final rule deeming vaping products to be tobacco products, it had a duty to coordinate with state, local, and tribal governments before implementing the rule. It also means FDA's duty to coordinate continues to this day. Holding the Food and Drug Administration's feet to the fire regarding its duty to coordinate is the EVCA, the Electronic Vaping Coalition of America. Founder Mark Block reached out to maverick lawyer Fred Kelly Grant, who for over the last 20 years has successfully challenged a variety of federal regulations through the coordination process. Grant specializes in regulations issued by the Environmental Protection Agency and governed by the National Environmental Policy Act, or NEPA, which is the law where Congress first codified coordination back in 1976. Convinced coordination could help pressure FDA into negotiations, Grant and the EVCA organized 2 public hearings with elected officials from the village of Heartland in Wisconsin and from the town of Windham in New Hampshire. Over the course of the hearings, the coalition presented testimony from nearly 24 witnesses, including public health researchers, industry experts, and local e-juice manufacturers.
We expect to show you that through vaping, people who want to get off of the cigarette habit have been able to do it, and that's the one way they've been able to get off and stay off.
The purpose behind the coordination hearings is to provide local officials the facts dispelling mainstream myths about the dangers of vaping, to demonstrate the benefits of vaping as a tool for harm reduction, to review the local economic impact of the deeming regulations, and to prompt regional officials to notify the Food and Drug Administration that they request coordination proceedings to begin.
It does give you sufficient governmental status to say to Food and Drug and the other agencies, we expect you to coordinate with us. We expect you to deal with us when it comes to issuing regulations that impact our town, our citizens, our taxes, the corridor in which we live.
What Fred Kelly Grant just described is the power structure behind coordination. An individual group or company have no authority to request coordination with a federal agency. Only state, local, and tribal governments can do that. Therefore, the primary goal of the hearings is to gain local government action. A clear win came out of the Heartland hearing, as the village subsequently sent official notice to FDA requesting the agency start coordination. On top of that, Village of Heartland President Jeff Vanderstill appeared at the following hearing in Windham, New Hampshire, as a supporting witness.
Explain to them what you've done in Heartland and what's happened in the brief time you've been in the coordination.
We have a business in Heartland that employs quite a few people. They make what's known as vape juice, or the solution that goes into vaping, and with the regulations that have come about that I really learned about in going through our hearing, and how damaging they are to these businesses, are going to cause a detrimental effect, if not a complete annihilation of this company. So all of a sudden we found out by going through this coordination hearing, you have an economic impact on your region and your area. You have a public health impact due to the nature of what vaping does and its harm reduction. And you also have the impact of the federal government not coordinating with you and just throwing something down and saying, this is the rule, follow it. So as we went through that, it was extremely staggering to me, because I had heard all the hoopla that people had heard in the past also that make people think, oh, it's bad, popcorn lung and all kinds of stuff. It turns out a lot of it is exactly what I call it, and it's hoopla.
Joining us today to talk coordination is Andrew Agler. He's the CFO of Savior Vape, one of the country's leading e-liquid manufacturers, and member of the Industry Advisory Board at the Electronic Vaping Coalition of America. Andy, thanks for coming on the show. Let me start with letting our viewers know you're also a practicing lawyer and have some experience with regulatory law around vaping. So Andy, what were your thoughts when you first heard about coordination?
In administrative procedures, essentially where the FDA kind of draws their power, they're oftentimes allowed to regulate as long as there's kind of an intent from Congress to do so. But the problem is that the big agencies have a lot of deference. They're allowed to interpret their own rules a lot of times. The courts oftentimes, because they defer to the agencies, will kind of throw it back to them as long as there's a reasonable interpretation of the rules. What I liked about coordination is you either did it or you didn't do it. Essentially what happens is that because it's mandated by Congress, it's very difficult because it's not an administrative procedures issue. It's just hey, in the statute, did you coordinate? No, you didn't. I didn't really see what the defense to that would be. It's either you did it or you didn't. So as a procedural point, and it is something that the administrative agencies are supposed to be doing anyway. They just oftentimes don't.
Andy, I'd imagine some federal agencies might consider it to be a disadvantage if local officials know too much about coordination. Walk us through that.
So essentially what you want to happen is, and that's why we do the hearings, is first we essentially, from procedural and a process point of view, we'll approach a local municipality. It won't per se be me, it can be a coalition, but it can be a local member. It says, you could go to your city council, wherever it may be. You reach out, we try to present the evidence to them to show them what the harm to the local community is. And if that local community, if the city council or, in New Hampshire, it's the selectmen, it's the village in Heartland, whatever it may be, it's essentially to tell them what the issue is, and it's up to them to decide if they want to coordinate or not.
Andy, we do know FDA is well aware of coordination. Following the hearing in Heartland, village officials met with FDA officials in Washington, D.C. to discuss coordination. Also, FDA is currently in coordination proceedings over the FSMA, the Food Safety Modernization Act, which, according to a report from the GAO, isn't going too well. But, at least the FDA is working on it.
They're really making an effort to coordinate. They've set up, I believe, a coordination center. They've also been setting up boards and interacting with the local communities, things of that nature. So that's really what the vaping industry wants. You can look at some other things, Regulatory Flexibility Act, including a lot of presidential executive orders. You'll see similar language, but in particular, the coordination language in the FSMA really does go above and beyond. And I would look to that language as well, along with NEPA, say, look, this is a pattern, this is a trend, this is just what the vaping industry wants. Everybody supports reasonable regulations, but do it in, do what you're doing with food. Don't treat this industry differently. So that's kind of what I think.
Andy, do you think the coordination process is a kind of fail-safe for democracy?
Yeah, it's a good question. The answer is you hope so. I mean, when you read a coordination statute and you read the way it's written in NEPA, when you read the way it's written in the FSMA, it sounds right. It sounds exactly what Congress wants. You're not passing laws in a vacuum. You're passing laws because real people are affected by it, and it's not that courts won't rule against administrative agencies. They do. But for whatever reason, with the scope and power of agencies these days, coordination really, from a separation of powers perspective, really is the right answer. It's to say, look, even if you're doing all these things, coordination is mandated by Congress. You have to do it. It doesn't matter because Congress wanted to do it. And for a court, it should be very easy for them to say, well, did you do this or did you not do this? That's it.
Final question, Andy. What happens if FDA doesn't coordinate with the vaping industry?
What happens if they don't coordinate? You go back and on appeal or something else, and the court says, look, there's no way that vaping existed back in 2009. This law was designed for cigarettes, and you can't regulate this at all. There's just so much risk for the government on this end to not coordinate and to not do it. And and to your point about democracy, a lot of the public officials that are appointed to these agencies aren't democratically elected. They're appointed. I have no say in who the commissioner is, good or bad. So I think that's another thing that just reemphasizes how much you need coordination, because there is no democratic process to elect an official who's deciding, essentially that I can't be in business anymore.
Well, that's it for this edition of Reg Watch. Before you head off, please like us on Facebook and don't forget to follow us on Twitter. For RegulatorWatch.com, I'm Brent Stafford.